Of the Court of Criminal Appeals, the Eastern Division. On the panel today are Judge Camille McMullen, Judge Jill Ayers. They are from Memphis and Clarksville, respectively. I'm Kelly Thomas. I'm from Maryville. First of all, thanks to Nick Morgan and Francesca Kraft. They do all the behind-the-scenes work necessary to make this happen. We appreciate that very much. Thank you all for being in attendance. 20 minutes per side. If the appellant wants to reserve some rebuttal time, let me know when you start your argument. I don't think there are any preliminary matters, so if you will, call the next case, please.
State of Tennessee versus Jacob Evan Coyne.
Mr. McDougall?
Yes, Your Honor. Good afternoon to the court. I am John McDougall of the Hamilton County Bar. I would like to reserve 5 minutes for rebuttal.
Very well.
And this is a case of a robbery gone wrong, or alleged robbery. What had happened in this case to the court is that Jacob Coyne went over with some of his friends. He had testified under oath that he was getting a ride from them. Basically Zachary Chadwick and Eddie Valenzuela and Alyssa Roberts had tried to buy some pot from the victim, Jalen Little. Mr. Little took their money and ran off. So they searched for him. Turned out that Mrs. Roberts was able to find him through the Find My iPhone, because the iPhone had previously belonged to Zachary Chadwick. Mr. Chadwick drove over with the defendant, Jacob Coyne, with Eddie Valenzuela. Eddie Valenzuela drove, and Alyssa Roberts was a passenger. Mr. Chadwick and Mr. Coyne got out of the car, went to confront the thing is that Mr. Chadwick was going to go ahead and confront Mr. Little about running off with his money that he was supposed to buy pot with. Mr. Coyne said he went to the restroom. When they came back, when Mr. Coyne came back, there was a confrontation between Mr. Chadwick and Mr. Little. Mr. Coyne's testimony was that Mr. Chadwick had shot Mr. Little. The testimony of Eddie Valenzuela and Alyssa Roberts was that it was Mr. Coyne that had shot him. And then there was another witness that did testify, who was Dante Little, who is the brother of Jalen Little, who was in the car, and said that there were two club figures, but the larger figure was the one that shot him, who he believed to be Mr. Coyne. When the police got there, they actually got a statement from Mr. Little that it was Zachary Chadwick that shot him. Mr. Chadwick and everybody left the place. Mr. Valenzuela and Ms. Roberts gave statements to the police. They caught Mr. Chadwick, and they later on caught Mr. Coyne out of county with the help of his mother. Mr. Coyne's mother helped find him and everything. From there, we had a hearing. The hearing was because one of the things on the hearing was whether or not Mr. Valenzuela and Ms. Roberts, if they would be considered, since they were riding along in the car, whether or not they be considered accomplices in this matter. And we did have a hearing as to the accomplice, and the court determined that they would leave that up to the jury to make a determination if they were. I will let the court know that there was really nothing to show that there was any planning of any robbery. Basically, the testimony of all concerned was that they were riding over. Nobody said too much. They went over. Nobody talked about robbing. The two of the witnesses said they didn't even know there was a gun. Well, three of them said they didn't know that there was a gun. Mr. Coyne said that he didn't know about the gun. Of course, he's saying he didn't shoot him. The other two said that they did not until allegedly Mr. Coyne drew the gun and but they didn't see the shooting. They didn't see him shoot Mr. Little. And therefore, one of the things we had, the only person that stated that he saw who shot him was when Mr. Jalen Little stated that the person that shot him was Zachary Chadwick. Of course, with the trial, one of the things that we have, one of our first arguments is whether or not there was sufficient evidence to go ahead and show that Mr. Coyne did go ahead and shoot, because Mr. Coyne was convicted of first-degree murder, felony murder, and robbery. For first-degree murder, of course, as the court knows, it needs to be premeditation. I don't think there's any premeditation shown in this trial. Basically, the testimony was that 1 minute there's arguing, that they're talking, then there's arguing, then there's a shooting. Of course, I know that what they go by is that can be in a blink of an eye that there could be premeditation. Of course, there's nothing to show that there's any type of premeditation in this, but there's also, we're citing the evidence to show who indeed did shoot Jalen Little. Mr. Coyne and Jalen Little's dying declaration says that Zachary Chadwick shot him. Then, of course, the two people that were in the car stated that it was Jacob Coyne that shot him. And with the trial, of course, he was found guilty of premeditated first-degree murder, felony murder, and robbery, and aggravated robbery. Our contention, or Mr. Coyne's contention on this, is that first off, the evidence should have shown that it was not him that shot Mr. Little. It was Zachary Chadwick that shot him. That he knew, that he didn't know of anything, that there's no plan to go ahead and shoot Mr. Little, that there's no plan to rob him. Of course, they were. I know that self-help in this case, that if Mr. Chadwick did use that, would not be able to be used. Now, one of the things that was stated as well by two of the witnesses, Mr. Valenzuela and Ms. Roberts, was that when the parties ran back into the car, they found that Mr. Coyne gave a 20 or threw a 20 over to Mr. Chadwick and said, "Sorry, that's all I could get." Now, the testimony by the police was that at the scene that was taken off, that money that had blood of Mr. Little on there, that was supposedly from his person when he was shot, that there was about over $900 worth of money that was there. So if robbery was the deal, and they only got the 20, and there's no sign of any of the 20, because they pretty much got Mr. Chadwick, Chadwick after the robbery, and the money that he had on him, none of it had blood on it. Whereas the money that the police recovered from the scene, that was actually picked up and was hidden, that they found later on in the house, had blood and burn marks over it from the gunfire. So there's a question whether or not, if it was a robbery, that why was there only $20 taken? Why was there? Why did the blood that they got from Mr. Chadwick? Why was there no blood or burn marks on it? And of course, Mr. Coyne did not keep any of the money. He supposedly gave him $20 because that's all he could get out of this allegedly $900 that was off of Mr. Little. That was one of the things that we looked at. Of course, with the elements of robbery, there has to be, and of course, could be an attempt robbery as well. But in this case, essentially, the testimony was that he shot him, grabbed the money, and ran, and not that basically a demand for the money or anything else for that matter. And why you only get $20? Why not get $900 or anything else like that? There was also the gunshot residue that the police got from the car that the parties got into. All the gun residue came from where Mr. Zachary Chadwick was sitting. There was no gunshot residue from where Mr. Jacob Coyne was sitting. Therefore, if Mr. Coyne was indeed the person that was that had shot him, there would have been gunshot residue where he was sitting on the door handle, and there's none there, but there was some on where Mr. Zachary Chadwick was sitting. So there's nothing to go ahead and show the elements for felony murder. There would have had to been a robbery, or that Jacob Coyne would have was involved with a robbery. And there's nothing except for the testimony of Eddie Valenzuela and Alyssa Roberts that Mr. Coyne was the one that gave Mr. Chadwick $20, and that was all that he could get. Of course, we would avert to the court that, of course, I mean, the jury, I don't think the jury found that there was anything to show that Mr. Valenzuela or Ms. Roberts were accomplices out of this, but theirs was the only testimony that testified to the in front of the jury that Mr. Coyne had that gave him the $20 that he took $20 off of Mr. Little after shooting him. The testimony from Mr. Deontay Little, who was a witness and is the brother of Jalen Little, was that that basically the taller of the people, that everybody's wearing hoods, that the taller person shot his brother, then kneeled down and then left. So, but he didn't see any money taken either, but he was assuming that the money was being taken. Of course, we would aver to the court that that the elements for first-degree murder, premeditated first-degree murder. First off, there's nothing to show premeditation. None of the parties talk about that they were planning it, that there's any things of shooting it. Nothing to show that there's any guns. Secondly, for the felony murder, nothing to show that there is a plan to rob. Of course, I know that with the $20 it would be enough, but except for the fact that there's no sign of the $20 that was allegedly taken from Mr. Little in this case. And the court can go by my brief as to the case law that covers that, whether or not we'd aver to the court that the evidence that showed that it was indeed Mr. Zachary Chadwick who was charged along with Mr. Coyne in this in the murder. That Mr. Zachary Chadwick was the one that had beef because Mr. Little had stolen Mr. Chadwick's money that he's supposed to buy drugs with, and there's also testimony that Zachary Chadwick was since he had the problem with Mr. Little, was the one that was very angry with him. There's nothing to show that there was any connection or that Mr. Jacob Coyne had any anger towards him. So there's nothing to show that Mr. Coyne had any reason to shoot. There's no motive to shoot him. Mr. Zachary Chadwick had the reason to go ahead and shoot him. The testimony was that from Mr. Coyne was that he was getting a ride because it was winter and they were going to go ahead and take him after they went by Jalen Little's house, and he got out to go to the restroom. He got out because he needed to use the restroom. Mr. Little pointed him to the outside of the house. He wasn't going to let him come in the house. And when he came back, that's where the confrontation went. Also, the police, when they came, they talked to him and asked who shot him. And Mr. Jalen Little stated to the police, and the police stated that he knew what he was stating, that he stated that it was Zachary Chadwick. Of course, the jury, the pattern jury instructions basically leaves the dying declaration as another testimony of a witness. Of course, in this case, I would say it's more because this court has stated in the past that the testimony, basically you have somebody who has no reason to lie, he's dying, he wants to go ahead and wants to get the person that shot him, And so that's why the court has relied upon the dying declaration. As a matter of fact, for hearsay, it's one of the few exceptions that there is for hearsay, because otherwise it's hearsay. So in this matter, we would submit to the court that that Jacob Coyne, the evidence would show that Mr. Coyne did not shoot Jalen Little, that he had no gunshot residue on him, had none of the money on him. Nobody had any of the money, that he had no motive to shoot Mr. Little, and that the jury in this case, because I think they had 2 live witnesses and a witness that was not there because Mr. Little was dead, and of course they're getting dying declaration, did not give the dying declaration the proper weight that it should have been given, as it was as what was testified for.
You are up against your 5-minute rebuttal time.
Then I go ahead and turn it over to the state. Thank you, Your Honor.
All right, so thank you. General Ward.
Good afternoon, Your Honors. May it please the court. My name is Gary Ward, and I'm here today on behalf of the state in the matter of State versus Jacob Coyne. Your Honors, here on direct appeal, the sole issue that we're discussing is sufficiency of the evidence. Defendant challenges the sufficiency of the evidence both on his premeditated first-degree murder, his aggravated robbery, and his, essentially by extension, his felony murder convictions. And I think it's helpful in this case to deal first with the evidence supporting the aggravated robbery conviction, as it's this aggravated robbery that leads us into the shooting of the victim. Essentially what happens here is a friend of the defendant's, Mr. Zachary Chadwick, has a few $100s stolen from him by the victim. He comes back to his house where the defendant is located, tells the defendant what's going on, along with a couple other people who are in the room. And the defendant says, and essentially says, "It's okay, Zachary, we'll handle it. You know, it'll get taken care of." At this point, the defendant, along with his friend, Mr. Chadwick, and two other persons, Ms. Roberts and Mr. Valenzuela, drive to the victim's house. At this point, we get some differing testimony from our various witnesses. The victim's brother testifies that the victim's brother watched this incident unfold, testifies that 2 people got out of the car, a taller guy and a shorter guy, that the taller guy, that one of these 2 people asked his brother, the victim, about the money, and that the taller man shot the victim. This testimony is supported by the testimony of Ms. Roberts and Mr. Valenzuela, who indicate that the taller guy is Mr. Coyne, the defendant, and that it was Mr. Coyne who shot the victim here. These eyewitnesses that traveled to the scene with the defendant further testified that immediately after the shooting occurs, that the defendant gets back in the car, hands some money to his friend, Mr. Chadwick, and says, "I'm sorry, this was all I could get," essentially apologizing for not being able to rob more money from the victim. Your Honor, that's the sort of meat of the state's case here. We have multiple eyewitnesses who testify that the defendant, when he found out that his friend had been stolen from, told him that he would handle it. This is a statement of intent. We're gonna get this taken care of. These eyewitnesses further indicate that the defendant brought a weapon with him. There's testimony at the trial that that when the defendant and Mr. Chadwick were speaking with the victim, that they specifically asked him about the money, and that the defendant then shot the victim. I would suggest to this court that the testimony of the eyewitnesses, the people who were with Mr. Chadwick all night, who heard him state that this would be handled, that saw him hand the profits, the gains of this robbery off to his friend, Mr. Chadwick, saw him apologize for not being able to get more money, that in the light most favorable to the state, that this testimony is sufficient to establish all of the elements of aggravated robbery, that the jury was well entitled to rely on this, the testimony of numerous witnesses, to find the defendant guilty of aggravated robbery. And we essentially have the same story when it comes to first-degree premeditated murder. Multiple eyewitnesses identified the defendant as the shooter. And like many other cases dealing with premeditation, we don't have, a statement of premeditative intent. The defendant doesn't announce to the world, "I'm going to shoot the victim." But we have multiple circumstances that Tennessee courts have identified as being evidence in circumstances that are indicative of premeditation. The trial evidence showed that suggests that the victim brought the gun with him to the victim's location, that the defendant shot the victim while the victim was unarmed, that the defendant immediately fled the scene rather than attempting to render aid after shooting the victim. Additionally, the medical examiner's testimony was that several of the wounds, that there were over a dozen bullet wounds on the victim's body, that some of these wounds were inflicted on him from behind, suggesting that the victim had attempted to run or had fallen to the ground, and that the defendant continued to shoot him. I'd suggest to this court that the testimony of the eyewitnesses identifying the defendant as the shooter and these facts and circumstances that I've just outlined are sufficient in the light most favorable to the state to establish first-degree murder. Your honors, what this case essentially comes down to is competing evidence. The defendant points to evidence that he argues means there's not sufficient evidence for premeditated murder. He points to the lack of gunshot residue evidence, the testimony of other witnesses that identify Mr. Chadwick and not himself as the shooter. What this is, what the defendant's argument is, your honors, is essentially a complaint about the weight of the evidence, about the way the jury weighed the evidence presented to it at trial. That's not appropriate here on sufficiency review. The sole inquiry is whether the evidence viewed in the light most favorable to the state is sufficient for a reasonable trier of fact to find the defendant guilty. I submit to this court that the answer to that question is clearly yes.
Was the jury instructed on criminal responsibility for the conduct?
They were, your honor. There was a criminal responsibility instruction given, your honor. Unless this court has further questions, I would ask that you affirm the judgment of the trial court in all respects.
All right, sir, thank you. Mr. McDougall, you have your 5 minutes for rebuttal.
Thank you, Your Honor. I will not be using the entire 5 minutes. Just two things. First off, the state points to the fact that it says it would be handled. Of course, I think that was one person testified to that. Other than that, there's nothing to show how it would be handled. That indeed, Mr. Coyne said he would be going ahead and would be trying to kill Jalen Little or hurt Jalen Little in any way. Also, the state responds that, well, there's another witness that states that somebody else did it, and that's actually the victim that stated that was shot. And I think the victim would know who indeed shot him, and and would have no reason to go ahead and say it was Zachary Chadwick if it was not Zachary Chadwick. In this case, we would state that we're not asking the court to go ahead and reweigh that. We're asking the court to state if the elements of each crime were gone ahead and proven beyond reasonable doubt, sufficiency in the light best for the state. We would aver to the state, aver to the court that the state had not gone ahead and proved that. Basically, you had two people who, like I said, I don't know why the jury didn't consider them accomplices because they rode together. One found the victim. The other went ahead and found and drove them over there. Both testified they didn't know that what was going on. I think that's one of the reasons why the jury didn't find that, but they were basically involved with this as well. Could have been felony murder. But in this case, Your Honor, there's nothing to show that. Basically it's only their testimony that says that Mr. Coyne's the one that went ahead and robbed it. No other physical evidence or anything else like that. You have the two of them with the same story. Basically, they both identify $20. They both say that he gave it to Mr. Chadwick and said, sorry, I can get more. So whether or not, like I said, I guess it's the jury makes the determination, but I think the court can still go ahead and determine. The court doesn't sit there and not go ahead and have the power to go ahead and review certain things. They can't go ahead and retry the case, but they can go ahead and look at the evidence and determine if it's sufficient or not. And we'd ask the court to go ahead, reverse the findings and send it back for a new trial, if not outright dismiss the case against Mr. Coyne. Thank you, Your Honor.
Thank you. Thank you for your arguments, gentlemen. Madam Clerk, if you will recess court for the day.
This Honorable Court of Tennessee is adjourned until October 27, 2021.
Thank you.
Thank you.